Yes.
My Lord, during the lunch and adjournment, I handed up two cases which I'd meant to allude to right at the start of my submissions, and I'm sorry for not doing that. They are two cases that came to my attention after the bundles were prepared. Can I deal with those now? They fit into where we've got to. The first, Radakovitz, which is the IRLR, the Industrial Relations Law Report, is very brief. It's at the margins of what's going to assist you, but in view of the fact I don't have an opponent, and notwithstanding you have been and will be assisted, thought I should err on the side of caution. Before I take your lordship to it, which will be very brief, and your ladyship, a very brief summary, it's another case about whether an originating application was presented within the 3-month time limit. And in short, what happened is that the employers originally said that they thought it was submitted out of time. They then wrote a letter to the tribunal saying they didn't intend to take the time point. But then at the start of the hearing, the tribunal raised it of its own motion. And this really confirms the Rogers and Bodfari case, which is in the bundle, which says that this is a matter of jurisdiction, so can't be agreed. And there's an observation by Lord Justice Elias recorded in the head note, which in a nutshell is worse the effect that tribunals have to guard against exercising a jurisdiction when the statutory conditions are not met, but they're not bloodhounds who have to sniff out potential grounds on which jurisdiction can be refused. There is not very much I accept in here that's going to assist you directly, although it is yet another example of litigation arising out of the question of the correct and effective date of termination, and an affirmation, not that any were needed, that this is a matter of jurisdiction for the employment tribunal. The other case will certainly be of interest, although ultimately how much assistance the court derives from it, I'm less sure about. This is a decision of the Court of Appeal with two issues identified in the first paragraph of the judgment, which I've handed up. The first does not matter. It's the second over the page. At the top of page 2, whether an employer who's committed a fundamental breach of contract can cure the breach while the employee is considering whether to treat it as a dismissal. The answer, my lords and my lady, is no. And the key paragraphs begin at paragraph 32. And it may just be easiest if I ask the court to read from there, or really it's paragraph 36 where it really begins, up to paragraph 44.
Yes. Yes.
I was going to pause there and make very brief submissions before inviting the court to read what Lord Justice Jacob has to say about that. So if I may, but as the court will have seen from that, the reason why it's obviously of interest is because it's a discussion of the interplay between what one might call ordinary contract principles and employment law. And the correct analogy here would be if one imagined a time before Brown were decided, when the argument was to say, well, ordinary contract results produce this principle, and just as Lord Justice Sedley is asking in this case, and as he says at paragraph 42, contracts of employment are not like the generality of contracts, they're inherently personal and they concern one of the most important things in most people's lives. Should we introduce a different rule for that reason? He says with considerable regret, the answer must be no.
Yeah.
That's by no means all of my submissions, but having made that very brief submission, if the court then looks to see what Lord Justice Jacob said, it's paragraphs 52 to 56 are the key paragraphs.
Well, what do you say we particularly get from Lord Justice Jacob then?
Well, you recall a moment ago I introduced it by saying it's certainly of interest, but how
Yes.
much direct assistance it provides I'm less sure about, because of course it doesn't say anything at all about Section 97
No.
or the issues before this court.
No.
But it's a relatively recent, i.e. earlier this year, discussion by the Court of Appeal about one of the issues in this appeal, which is the interplay between what one might call ordinary contractual principles and the employment sphere, and the extent to which one should be modified when applied in the other. And so what I say that the court should take from this is that it's more than a presumption, it's an assumption that the correct way to proceed is that ordinary contract rules apply in the employment sphere, unless there is a good reason why they should not.
Yes.
And secondly, that the reasons why not, if I can put it that way, have to be pretty compelling. Because Lord Justice Sedley thought that at least there were very good reasons on his view, and that's why he expressed regret at coming to the conclusion that he did. But notwithstanding that, his judgment was that in spite of the good reasons, one had to remain with the ordinary principles of contract law. And third, there is a suggestion by Lord Justice Sedley alone, I accept in paragraph 44 that concepts should only be introduced into employment law on the grounds that were capable of extension to other contracts. So that may not be right, I accept. It may be that one can say, well, this is a purely, particularly in the context of this appeal, where it's a statutory provision, rather than employment law in general terms. It's a specific part of an act and a small number of specific sections. But at least it was a consideration that carried very great weight with Lord Justice Sedley.
It's worth noting, though, the first sentence of paragraph 20, because he has said at paragraph 19, as I think we all know, that modern employment law is a hybrid of contract and statute, and well, contract and status, he says, and then statutory protections are grafted in. And then the first sentence is setting the scene for, I think for what follows, which is that the particular topic that he's going to discuss is not determined by the statute, but by the common law, and then leads into the discussion you've been talking about.
I accept that entirely, my lord. And the obvious difference here is that we're concerned with the statutory provision. So that's why I say I don't suggest to the court that this takes matters enormously further either way, but I think it does take matters a little bit further by showing that the Court of Appeal, at least in this case, has properly recognised that the starting point is contractual. Well, it's the three reasons I've summarised, my lord. I don't want to repeat myself. Whether this is a fourth reason or the fourth matter I rely upon out of this is just very briefly Lord Justice Jacobs' sentence that has been the common law rule for all kinds of contracts for centuries. It works, those two sentences. There's a very faint echo of what I was saying, that these are not an arbitrary set of rules. They've developed over time and have, at least in one context, an inherent value, and therefore they provide a good starting point for another. So, my lord, I hope the court understands why I draw that to your attention, and I hope that there will be some assistance, albeit limited, derived from that. But to return to where we were before the adjournment, on the issue of whether posting is enough, I risk of repeating, because I do want to emphasise that is not my primary or only submission. You recall, my lord, I said that whether we're right about posting or delivery, this appeal must be allowed. So I don't hold a brief for one argument over the other. And I can quite see that there may the reasons for, if I can put it this way, some discomfort at the idea that an employer posting a letter is enough. I would simply reiterate that the only assistance or observations I can offer to the court to try and allay that discomfort is leaving aside section 128. There are no obvious practical difficulties, and it is consistent with ordinary principles of contract law.
Yes.
But what that leads on to in my submission is that if that's not right, then we get to the position of Lord Justice Lloyd in the Court of Appeal, which I can say that one can go no further than this in terms of placing burdens on the employer, that once the employer has achieved delivery, then there is no scope for any suggestion that the employer... Sorry, I'll start that again. There is no scope for holding that something more has to happen before a termination takes effect.
As between the two, I happen to have open LTE against Clark. This is tab 12, and I'm looking at Lord Justice Templeman at page 368, where he's talking about repudiation and what's necessary to accept repudiation under ordinary contract law. And what he says, I think particularly at between D and E, acceptance can take the form of formal writing or can take the form of refusing to allow the worker to resume or continue his work. And at first sight, that looks like the equivalent of just, as it were, signing the letter and put it in the post. But when he comes on later on, I think it's really the idea of the equivalent, refusing to allow the worker to resume or continue his work, is something that is actually communicated to and known by the worker. And I think when he talks about writing the letter, he probably includes delivery of it, so that the employee rather knows what the position is. I mean, it's not very fully fleshed out here, but at letter G, he talks about writing to the employee, informing him of their decision. So it's a communication which is achieved, I would have thought, at the point of delivery, on your argument, not on the point of posting.
Well, my Lord, I don't suggest that this particular authority directly supports the idea that posting is enough. I think it's an example of where posting appeared to be enough, but it may be because of the... Similarly, perhaps to Radetzky, it's not entirely because it wasn't directly an issue.
No.
It's not specifically referred to. Certainly nobody really seemed to trouble to inquire as to when it was received or when it was read.
That's right. Yes.
Well, having said what I did about not holding a brief for either argument, it may assist if I indicated that I can see the arguments in support of Lord Justice Lloyd's approach are far stronger than those in favour of an argument that merely, if I can call it that, posting is enough.
Yes. And
I say that because, for two reasons, but again split between principle and practice, is that there is perhaps more authority for the point of principle about delivery having to be achieved. And so one sees that, for example, in the Brimners itself. Neither the High Court nor the Court of Appeal speculated as to what would happen if the telex hadn't been received, but one can see that was a case of actual delivery. And also one can see, as a matter of practice, because I've tried in all my submissions to take account of the practical implications, that taking that extra step, as I think I've put it in my written case, comes closest to striking the balance between the position of the employer and the employee. So that whilst an employee might have some grounds for feeling aggrieved, or might even be practically disadvantaged in the short term, certainly in the Section 128 application, if the EDT was when there was posting, if one gets to Lord Justice Lloyd's stage of saying, well, there's also been delivery at the address that you were expecting the letter and that you live at, then really one has to stop there. And one can't say that the termination has not taken effect and something else has to happen after that. Because after that it is entirely out of the hands of the employer. There's always scope in the postal rule, if I can call it that, for saying it's not right, the employer could do a bit more. The employer could actually ensure, for example, by hand-delivering the letter himself or herself. But it is impossible in my submission to see what else an employer could do once the employer has actually... Well, I'm sorry, maybe I have to take that back, because of course what they could do is find the employee in person. So that could always be said. They have to track down and effect personal service in something of the manner of a process server. So I retract that immediately, but that example itself illustrates that that is taking the matter far too far. There is no authority, no support for that as a matter of principle in the authorities, and as a matter of practice, it's very difficult to see what the practical reasons are for imposing that additional burden on the employer. I'm talking about beyond delivery, somehow getting the employee face to face and conveying the dismissal. So I say that to try and assist. But the court will also have seen that I've suggested some other options in my written case as to what the rule could be, one of them being the rules in the CPR, the other being some sort of inquiry into what was reasonably expected at the time. But as I've indicated in my written case, that is going to introduce more uncertainty than the present rule. So, for the sake of having a clear submission for me, what I say is to assist you on this point, not that it affects the outcome of the appeal, is that there is a great deal to be said in favour of the conclusion reached by Lord Justice Lloyd. And if the court is looking to lay down a clear rule, it should endorse what Lord Justice Lloyd said.
Going back to what Lord Slynn said in Brown, are you aware of any academic commentaries or any hints in the textbooks that suggests a suspicion as to whether or not that was the right approach, or is it just simply accepted in the textbooks and the other writings?
My Lord, so far as I'm aware, and I don't claim to have considered all the academic journals looking for those, but certainly if one takes the Employment Practitioner's Bible, which is Harvey, it will just say that's the rule.
Yes.
It makes the observation from recollection that McMaster appears to be slightly stricter in its wording. And, for example, the reporting of this case in the Court of Appeal has been referred to in the Industrial Relations Law Reports, which has an update every month. And it's also, as you will have seen from the bundle, Holsbury's statutes have mentioned it. But there is nothing said by way of commentary on that point, my Lord. Can I, at this point, though, slide into the narrower ground of appeal? Because in my submission, looking at that casts a great deal of light on the wider ground of appeal. Because if one looks at the stage that I've reached in my submissions of looking at what the test should be, either the postal, when the employer has done everything that it can short of delivery, or whether it's Lord Justice Lloyd says there has to be delivery as well. The final stage, which is the Brown rule, is to say that you must have actually read it or had a reasonable opportunity of reading it. And that, of course, is a matter entirely out of the employer's hands. Short of, as I've said, personal service, there is nothing the employer can do. At that stage, the matter is all entirely up to the employee. But I don't suggest that the rule is arbitrary or has been arrived at or come to for no good reason. The rationale for it is obvious in my submission. For want of a better expression, it's an employee-friendly rule. It's there to protect employees from the possibility that they will, for some reason, not be aware that they have been dismissed. And so to protect them against the potentially adverse consequences of that failure, whatever it might have been. That, I think, is clear. But the facts of this case and the application of the test in this case shows the problem with that and shows that the rationale, whatever it was back in 1980, the way it was applied by the tribunal in this case, has moved a very long way from that.
I've had some difficulty in grasping exactly what the point is, reading your written case, because the way one reads Brown, this is back in tab 4, page 628, is to look at the position of the employee between B and C, rephrasing it slightly. Did the employee have a reasonable opportunity of reading it? Or further down the page, between G and H, did the employee reasonably have the opportunity of knowing about it? And the emphasis is on the position of the employee and what the situation was at the time, looked at reasonably from his or her point of view.
Yes.
That much is common ground, is it?
That is the emphasis of the judgment, yes.
Yes, that's what Brown seems to be saying.
Yes.
But are you disputing?
No, I'm not, my lord, but I'm trying to articulate what I think is obvious. It's not entirely... it's just the rationale for that. And the rationale seems to be, because the reason I say it's obvious is because it's what would expect the justification to still be today. It was part of Lord Justice Mummery's reasoning for it. It's there to guard against the possibility that something goes wrong between the decision leaving the employer and coming to the conscious mind of the employee, and to protect the employee against any potentially adverse consequences of that. I've already made the submission that there don't seem to be any significant practical consequences so far as Section 111 are concerned, because there's the safety net of reasonably practicable to deal with things going wrong.
Yes.
But nonetheless, I understand the rationale. But the facts of this case, as the court knows, were that the employee was anxious to know the result. She had asked when the decision was going to be sent to her, and she made clear, in fact, that she was planning a trip to London, although she didn't say, according to the minutes, exactly when she was going. And the letter came after she had left, but she accepted this important finding of fact set out in my case, that she could have made inquiries about the letter whilst in London, but she did not. Because, of course...
Can I just catch you there? The problem that those propositions gives rise to in my mind is this, that it's essentially a question of fact, really, to assess these facts and circumstances and put them together and come to a conclusion. And we've got the tribunal at page 41, I think, in the core volume, which reaches its conclusion, and then the EAT at page, paragraphs 20 and 21, I think it is, and the EAT reach the same view. They accept and indeed affirm. So you've got concurrent findings on the raw material, that the conclusion is in her favour.
My Lord, I entirely understand.
One has to accept that. We can't disturb the findings so long as the tribunal directed itself correctly in law. And therefore, I'm searching for the moment to find a misdirection.
Well, my Lord, I can entirely understand that point, and it's both as a matter of forensic consideration of what's said in this case, and also as a matter of instinct. It's entirely understandable. I do say there's been a misdirection.
Yes.
And the misdirection has been, and I say this in my written case, that's paragraph 50, at the bottom of page 16, the tribunal made a merits assessment of the reasonableness of the claimant's position rather than assessing the reasonableness of the opportunity. Now, of course, I see the objection to that. That's a distinction without a difference, it might be said. But in my submission, it wasn't. When one considers what the rationale of this rule is, or perhaps more to the point, what the rationale of this rule ought to be. Because this narrow ground of appeal, my submission is, well, if you're going to accept that Brown is in principle right, then what this court should do is to recast it, to make clear that this exception that Brown admits, this exception to the normal contractual principles, which if this be your decision, you're prepared to uphold for the practical reasons, perhaps those identified by Lord Justice Mummery, perhaps others. But if there is to be that, then it is very narrow, and it is narrower than the tribunal thought it was in this case. How narrow is it? It's to this point. The rationale is concerned with communication of essentially a yes-no answer. Because nothing that Mr. Justice Slynn said in Brown went any further than just the fact of dismissal. That's clear. If we look at, if the court has it open, it's in either, it was originally in tab 4, it's indexed as being in tab 5, page 628. Letter G, which I said was the clearest exposition of the ratio, the termination does not take effect until the employer has either been told of or has had a reasonable opportunity of reading the notice of dismissal. So it seems to me very clear from that Mr. Justice Slynn was not talking about communication of every last reason. A decision letter might actually be quite lengthy, particularly in a complex case. The moment of termination is not delayed until the employee has read every last word. And in the case of many employees, it may be they don't understand every last word, depending on how complicated it is. until they've taken advice. But it is essentially, there is a binary outcome to a disciplinary hearing, sacked or not sacked. That's the only piece of information that has to be communicated for the termination to take effect. The rest of the statutory mechanism is there to enable complaints to be made about the fairness, the inadequacy of the reasoning, the injustice of it, etc., etc. And so, that being the case, it can't be right in my submission, or at least this claimant doesn't fall within the rationale for this exception, because she could have found out whether she'd been sacked by the means of a simple phone call. And insofar as the tribunal is to be taken as finding that it was reasonable for her not to do that, that does not mean that the opportunity was not there and it was reasonable simply to find that out. The rationale is to protect employees who might not have any means of finding out. So if you don't know that you've got 7 days. To take the most extreme example that we've been considering, section 128, with no provision for extension. You've got 7 days. And so if the letter gets delayed in the post and you only get it on day 6, you might only have 1 day left to make your application. That might be a reason why this court would conclude that that should not be the law. But an employee who wants to know and has the means of finding out, as I've said in the written case, it must be very, very narrow indeed, the circumstances under which a tribunal can properly find that the opportunity you had was not reasonable.
Well, we're getting very, very close to an assessment of the facts, but I'd like to understand what you mean by the simple phone call. That's a phone call not to the employer, but to home.
Yes.
To ask somebody at home, has a letter come?
That's right.
And then presumably, please open it.
That's right.
Tell me what's in it.
That's right. Although she could equally have phoned the employer. I mean, to take the hypothetical scenario, which is the one under section 128 that may produce injustice, where the employee doesn't find out, that could not happen in a case like this, because the employee knows that they're at risk of being sacked. They'll have a fair idea in their own mind of whether they believe it's for a protected reason, so will entitle them to claim interim relief. They will know in advance, or they should know in advance, that they've got 7 days in which to make the application. They've been to a disciplinary hearing, they've been told the decision's going to be with them within 2 days, I posted the next day. The employee who chooses to go to London and not make a phone call is not the employee that needs protecting by an exception to the ordinary rules of contract. The employee who needs protecting is the employee who simply could not have found out. Because the letter just was not there, it was in transit. In my submission, one can even go so far as to say that one of the reasons I say it's very narrow is because it will be very rare in my submission that it will not be reasonable for an employee who's anxious to know, where that's the finding of fact as it was here, to phone up the employer, so even if there's nobody at home to read the letter. Different considerations apply, I entirely accept, where one has, for example, a complicated gross misconduct hearing, where the employer goes away and spends some considerable time thinking about, or perhaps even making further inquiries. It's not unusual.
That's all very well if you can express human reaction in black and white terms, but while in absolute terms it may be right that she had the opportunity to discover the outcome of the hearing. I mean, she was in London to visit her sister who had given birth, who had lost a child earlier, and the preoccupation of such an individual might be distracted away from what, in retrospect, we now think is an extremely important event, namely whether or not she was going to be summarily dismissed. But is she to be condemned because she allowed herself to be preoccupied by her sister?
My Lord, it's not the question of whether she's to be condemned ignores what happened subsequently, which is that if she'd been properly advised, then the claim would have gone in without this issue arising. So it's not so. In my submission, it's not quite so straightforward as to say that to accept the submissions I'm advancing can result in an employee being condemned. I repeat the submission I've made in writing.
Condemned was an unfortunate verb for me to use. Forget condemned. Is she to be disadvantaged in this fairly dramatic way in that she's shut out from any claim to unfair dismissal? Her employment is at an end, her legal rights are extinguished.
Well, my Lord, there's a mismatch in my submission between that consequence and the cause of it. It's too simplistic in my submission to say that because she didn't make the phone call, her punishment is that she can't claim unfair dismissal. The reality is, as I've said, one's always looking at these things retrospectively. The real reason why she wasn't or should not be allowed to bring her claim is because perhaps I should be careful about saying this. It appears from the decision that the most proximate cause of her not bringing the claim in time, if we're right, is a misunderstanding by her legal representatives of an entirely separate point. She put herself on her claim form that her date of termination was the date of the letter even. So insofar as one's considering, speculating as to what conversations might have taken place between her and her advisor about this, we can pretty safely conclude that it was not, we're relying upon the fact that you didn't read it until the Monday and calculating our 3 months from there.
Well, I think possibly a more effective answer to my question is that it's wrong to concentrate too much on the events in the immediate post-dismissal period. You've got to take into account the entire period when coming to a judgment as to whether or not the effective date of termination should be regarded.
Well, I certainly agree with that, my Lord. It ties in with the submission I made also about the need for certainty. And having this rule, again, I think one can properly speculate, supposing there hadn't been the confusion on the part of our advisors about the other issue, but nonetheless she had left it until that moment for other reasons which were not going to benefit from the extension principle of reasonably practicable. Or even suppose she's put the claim in and this point comes to life. Both her and her advisors, and my clients and those advising them at the time, have got to make a judgment on the law as to what the employment tribunal is going to make of whether there was a reasonable opportunity.
Well, what we have in front of us, and I'm looking at pages 40 and 41 in the core bundle, is the tribunal's assessment. And we're told about a dozen lines down into the page that the claimant gave evidence, and with certain other witnesses as well. And about 2/3 of the way down, the claimant had been put to stringent cross-examination by Mr. Hall, so presumably all the various points were put to her in the course of that cross-examination. And then they do say, near the top of page 41, that had she made inquiry by telephone, this would not have given her an opportunity to read the letter, but of course she could have discovered the contents and so on. And then I think about halfway down, in my view, the claimant did not have a reasonable opportunity of reading the letter until the 4th of December. While she may have been able to ask someone to read the letter over to her, she did not, and this did not seem to be an unreasonable position to adopt, given the reason for her absence from the home. Now, that's the entirety, I think, of the reason then. And then we get on to whether she should have asked for the letter when she got back home by train between 10 and 11 p.m., and he excuses her for that. And there's no real doubt about that, I think. But it's having heard the reason for her going away, what she was up to while she was away, and so on, the tribunal of fact has reached the view that she didn't have a reasonable opportunity at that stage. It wasn't unreasonable for her to adopt the position that she wasn't going to ask people to read letters out over the telephone.
Well, my lord, this comes back to the point where I can see the objection is it's a distinction without a difference. The question is whether the opportunity reasonably existed. Was it there? And in my submission, it can't be right that the issue of jurisdiction depends upon an individual tribunal's judge about the reasonableness of her position. It's got to be narrower than that in my submission, if it's to uphold the rationale of this exception to ordinary principles.
Well, when, as a matter of your submissions, do you say the reasonable opportunity arose?
On the day it was delivered, because she knew it was coming that day. She'd only left home a couple of hours earlier, and either from a mobile telephone or from a telephone in London when she arrived there, it would have been a matter of seconds, if not minutes, to make the phone call.
So on the facts of this case, a reasonable opportunity arose during the course of the day because she could have telephoned in.
There was, on an objective viewpoint, yes, a reasonable opportunity existed. To be contrasted with if something had gone wrong with the letter and it didn't get delivered until Monday.
She didn't actually say, did she, when she expected the letter to be delivered? Did she? I'm looking about a third of the way down page 40. She didn't make inquiries about any letter that might have been received during the period while she was away, although it was clear she was anxious to know the result. So she was anxious to know the result, yes, but she didn't ask about whether any letter had been received. So I don't think there's a finding against her that she knew a letter had arrived, or even that she was expecting a letter to arrive on any particular day. Is there? I mean,
the first no, the second yes, my lord.
Right.
There's no finding that she knew that it had arrived.
Yes.
But there is, if Mo gives me a moment.
Well, the transcript of the hearing.
I was certainly going to say the transcript of the hearing suggests very clearly that she was told.
She was told, because she asked, when are you going to decide? And she was told, I will be making up my mind tomorrow and sending you a letter, and you should get it therefore on the Thursday,
Yes.
the next day.
Exactly.
Yes.
I was just trying to see where that translates into the decision, but I'd be very surprised if...
However, if one's being objective about your approach, you must be saying that whatever the subjective circumstances of the recipient of such a letter, it is reasonable to expect them to ask somebody else to open it and read them the contents. We are here talking about a letter summarily dismissing somebody for gross misconduct, which is likely to include the reasons. Now, speaking for myself, I do not find it reasonable to expect somebody to ring somebody else up. And we're talking objectively, so not in the context of this particular woman's circumstances, ask them to open a letter, a confidential letter, and read out the contents in those circumstances.
Melody, I see that. The only thing I can say is that wasn't the argument that she made, and it wasn't a finding of the
Well, it is
tribunal.
actually the argument that was before the Court of Appeal.
Well, it was the argument before the Court of Appeal, but in terms of why she said to the tribunal, I did not have a reasonable opportunity, it was, I was in London and away. It wasn't as specific as that. And the employment tribunal judge did not mention that as part of the
Well, the reason I'm putting
reasoning.
it to you is that you are saying this has got to be looked at completely objectively,
Yes.
with objective, reasonable standards, and I say this can reasonably be expected of any employee who has just had a disciplinary interview. Possibly you would add on to that and being told the decision is going to be made promptly.
Yes. Melody, I can see that.
You can think of any number of scenarios in which that would be completely wrong.
Well, Melody, I can see that. What I would also say, though, is repeat the submission I made a few moments ago as to why this must be very narrow, is because if one is talking about ensuring an employee who wants and needs to know, then it's difficult to imagine circumstances in which it wouldn't be possible for them to phone up their employer. And that keeps all the confidentiality still applies. If the concern is, It all depends on what point the court reaches in its reasoning. If the court's position is that ordinary contractual principles would not dictate this result, but a separate approach is being applied in here for the practical reasons identified by Lord Justice Mummy or otherwise, then the rationale, as I said, that exception should only be extended to protect employees where really they just could not have found out. And whilst I accept that if she'd been told, well, the letter wasn't coming until Monday, or the letter didn't arrive until Monday, then the matter might be different.
Yes.
Though you still have the argument about being able to phone up and ask.
Well, I found the paragraph I think you were looking for, which is at page 36, paragraph 5.7 in the findings of fact. And you're quite right to correct me that she was told it would be in the post the following day, that's the 29th, would be received on the 30th. So that's the finding. And then we get paragraph 5.16, where she gives her explanation, saying it was up to her to read the letter and she didn't make inquiries because she was more concerned about her sister and so on.
Yes.
So, I mean, that's the raw material which he discusses later on.
Yes.
But is there anything to suggest that she appreciated that the date on which she was informed or read for herself the contents of the letter was critical to some future course of action she might take?
In terms of findings, no. I think to be fair, it was her evidence was challenged that it was in some way she tried to suggest something different because she knew the importance of this issue.
Yes,
but there was certainly no finding to that effect.
I can understand that as a line of cross-examination, but it doesn't seem that she was aware that there were particular time limits which she had to be aware of when she was wondering whether or not, if she did wonder, whether she'd make the phone call to get the letter read over.
No. Well, I accept that, but that's the artificiality of to that extent, of this debate as it was in Potter.
Yes.
And even as it was in Radetzky, where one date was given, where this is all being argued long after the event.
Yes.
And it comes back to my submission about one has to leave aside what's more important than what might be going on in those 2 or 3 days. It's more important there's a clear rule, so when everyone sits down after the event to work out whether the claim is brought in time or not, that there's a clear answer. Because, as I said, the problem with this rule, in this case as an example, is that trying to advise or know in advance whether this claim was in time or not, it shouldn't be left to the judgment of an employment tribunal judge.
If the claimant's boyfriend's son had not been at home, would there have been a reasonable opportunity on your submission?
Yes, my lord, for 2 reasons.
And what would the opportunity be?
The opportunity would have been to delay going to London until she got the letter, because she knew it was coming. And the second would have been to contact her employers. We're not dealing, as I said, with a letter that's gone astray. We're not dealing with someone who didn't know when the letter was expected and so took a holiday or was ill in hospital or anything like that.
So does your submission come to this, that her personal circumstances, for example, the wish to get the 11:27 a.m. train, or her concern about her sister's state of health and so on, really have to be let out of account? Personal considerations of that kind are to be left out of account because they can't be, as it were, predicted by the employer. The employer must just simply determine for himself, you would say, so long as I send it by post, by recorded delivery, I've done all I can to make sure it gets to her home address, and that gives her the reasonable opportunity. Is it as stark as that?
The answer, my lord, is no. I don't think they can be left out of account. But one has to consider very carefully what they are and how much weight they can have. A personal circumstance which consists of a choice to go to London is entirely different from a personal circumstance that one has been knocked unconscious by a car and is in hospital. For example, to take two extremes, one, as I indicated at the outset of my submissions, one can change the facts of this very slightly. If she'd simply gone to London to go partying with friends, I would say, is perhaps at one extreme, and being knocked over by a bus and being unconscious in hospital is at the other.
Well, it sounds very much as if it's a question of fact ultimately for the tribunal, so long as it directs itself correctly. And then one comes back to the question, what exactly did the tribunal misunderstand when they looked at the facts they found?
My Lord, I can only repeat the submission I've made, which is that it's the reasonableness of the opportunity. Was there the opportunity there? And I think the word reasonable is really only there to exclude fanciful possibilities. So for the purposes of my submission, I would simply drop that word and just say, was there the opportunity? Could she have found out?
In other words, you concentrate on the opportunity rather than the behaviour of the individual.
Well, that's right, my Lord.
But what about a case where, as here, the claimant's told that a letter's going to be sent, and you may say this is a fanciful case. She originally plans to wait in for the post, which nowadays doesn't always arrive that early in the morning, but then some emergency arises with a relative falling gravely ill or something like that, and she leaves the house and has only one thought in her mind, which is to tend to this gravely ill relative. Reasonable opportunity?
My Lord, I would agree with the suggestion that that is a question of fact, but I say that the tribunal, to direct itself properly, must ask itself the question in the way I put it, which is that really, was it possible for her to find out? So I would say, yes, there is a reasonable opportunity on that day.
But that is an assessment. In that case, that would in one sense be an assessment, a merits assessment of the reasonableness of the claimant's position. I'm quoting from your paragraph 50.
Well, my Lord, I'm not sure. I'm not sure it is. I would say it's a merits assessment, and it's a merits assessment of the opportunity that existed. I'd say it's easier for me to make my submission if one abandons the word reasonable, because that implies, I think that's only there to exclude completely fanciful possibilities. So if one says, is the opportunity there, then the only circumstances I can really think of in your Lordship's example would be if she did not have access to a phone, for example, for any reason throughout the whole day, so she could not have found out. But can I say this at this stage in the exchange? These submissions are directed not to my wider as well as my narrower ground of appeal. All of this demonstrates and supports my submission as to why this is completely the wrong approach to have to these matters. We're not concerned, I'm repeating myself to a certain extent, but to put the submissions in their proper context, we're concerned with a rule here that is related to the calculation of time limits for presentation of claims, most importantly, whether it's for unfair dismissal or interim relief. And not with the question of not with any other consequence, such as on day 2, what is the position there and then? And so if one has a rule along the lines that I've been submitting under the wider grounds of appeal, one avoids this complete minefield of uncertainty, where it's almost impossible in my submission for anyone advising an employer or employee as to what the outcome might be, when there's no good reason for that uncertainty. Again, leaving aside section 128, which I'll come back to, if the problem, whatever it may be, means that it was not reasonably practicable to present the claim inside 3 months, then that applies. The employee is protected. There's no question of prejudice. If it doesn't, i.e. it was reasonably practicable, then that takes account of all of these factors at that stage. But at least you have this clear starting point of it being out of time, and everyone knows and there's a lot of case law as to how that's to be construed, and the upshot of which is it's pretty narrow, and everyone knows you've got to have very good reasons before a tribunal will say it was not reasonably practicable. So these submissions, as I indicated, are directed as much to the wider ground of appeal as they are to the narrow, and by exploring these one can see the completely unsatisfactory nature, and also that there is no good reason for this rule. Certainly in the way it's applied. It doesn't uphold the original rationale, and it doesn't really achieve very much. The rule in this particular case, as I was saying earlier, doesn't have any real causative link to the delay and the issue that's being discussed.
In Brown, what happened was that the employee went away on holiday,
Yes.
didn't he?
Yes.
And the letter arrived, I think, on the Friday after he'd left his home to go away, and he didn't come back until the Sunday. And the finding was that there was no obligation on him to come back home to search for the letter. Although, on one view, once the letter reached his house, there was an opportunity. All he had to do was to go back home and get it. We don't know, presumably there was nobody else in the house, so it wasn't a question of phoning up to find out and get somebody else to open it. He would actually have to go back home from his holiday, and I'm not sure how far away he was, but it's not all that far removed from this situation, really, where there was something the employee could have done, but chose not to do for his own personal reasons, and time didn't run against him until he actually got back.
Well, I accept that, my lord, and I'm very conscious of the reluctance, principled and practical reasons of this court to interfere with what are properly characterised as findings of fact. But in this sense, it's a narrower challenge to the wording used in this tribunal decision, which is, say, if one looks at it, one can see from the wording itself in the decision that what the judge was primarily addressing himself to in his decision, although he uses the right words at the end, is the reasonableness of her position. And what that implies is that jurisdiction depends upon whether one goes away for the weekend for a good or a bad reason, or perhaps more than that, one can go further. Jurisdiction depends upon what a particular employment tribunal judge makes of the reasons why you went away for a weekend. That doesn't give certainty to either the employer or the employee. And so it's not a good rule. It's an exception to ordinary contractual principles that does not achieve certainty and really doesn't have an enormous amount to do with the rationale of protecting employees who, as I said, are protected already by the reasonably practicable exemption. So if, to go back to the case I handed up of Buckland, where Lord Justice Sedley was saying, well, should we introduce this change, there may well be good reasons. If Brown hadn't been decided and hadn't been the law for 30 years, the argument would be, and I think it's a very strong one, in my submission it's a very strong one, which is that there is no good reason, as there was not in Buckland, for departing from the ordinary contractual principles. That's not to say there aren't reasons in favour of it, as Lord Justice Sedley recognised, very powerful reasons. And this court may feel, having read that, the idea that an employer cannot hold out an olive branch, as Lord Justice Sedley calls it, and do anything about it, is to be regretted. But no matter, that is not, in that case it was not good enough. And in this case, I say, the reasons are not good enough to have this uncertain rule introduced, or in this case, upheld. And if one looks at it in that way, then one sees that the fact that this has been an EAT authority for 30 years really carries very little weight. because, as was said, I think in the application for permission to this court, what that leads to, as it did Lord Justice Mummery, is saying in his judgment, I have to be persuaded that a rule is wrong and productive of injustice. And that's simply not the way in which the appellate system works, in my submission. If the rule is wrong, the rule is wrong, and it's always been wrong. The declaratory theory of the common law is that the law has always been thus.
Well, there are questions of degree. I mean, one of the things that I think comes through your address is that we're dealing in a fairly narrow set of distinctions, and it would certainly add weight to our argument if it was possible to demonstrate that there had been protests about this and that the thing had gone wrong and so on, and the textbooks were questioning it and so on. Obviously much easier for you if that kind of undercurrent was present. It's more difficult if you have a rule which specialist tribunals have been using without that kind of protest for so long, and one wonders whether there really is anything really wrong with it.
Well, my lord, it certainly, this raises wider issues as to the extent to which the courts can take account of discontent with the law. And it may be that we were wrong to form the judgment that we weren't going to put in evidence about difficulties that it caused in practice. But in my submission, it's not the sort of thing that one would expect to see a huge amount of evidence about. Lots of rules of law that are overturned in the Court of Appeal or in this court are done so without that sort of evidence. And in any event, it is, I think, in my submission, it ought to be clear to the court without any evidence that it is perfectly capable of causing problems, albeit at perhaps a very low level. It might result in small-scale employment tribunal claims succeeding, or it might involve a hearing which perhaps only costs £1,000 or £2,000 in legal fees for both sides to attend. But the fact of the matter is it's a rule that introduces into jurisdiction the concept of reasonableness with all the uncertainty that entails. It's a departure from the ordinary rules of contract. So,
if I could just ask you, as I understand it, your submission is that the ordinary rules of contract lead to the conclusion that is this right? I don't want to put words into your mouth. That the employer succeeds in notifying the employee of the dismissal if he takes all reasonable steps to provide that notification. And in the present case, the employer informed the claimant that a letter would be sent giving the decision. The letter was sent to the correct address. It was recorded delivery, and that's good enough, although I think you're prepared to accept, and it's also proved that it was delivered to the correct address. But is the employer's obligation, the way I stated it, an obligation to notify the employee?
well, can I answer that indirectly, my lord? And then I'll try and answer it directly if my lord's not satisfied with the answer given. The first thing I would say is that the rule in Brown is not consistent with ordinary contractual principles. It's a departure. It exists as a rule on its own, without parallel outside of this particular issue. That's the first thing. Ordinary contractual principles. I cannot say what ordinary contractual principles always produce the same exact result, because what I've endeavoured to indicate is that if one starts, as one often does with Chitty and the citation of principle there, is that it's normally done by communication, but an unequivocal overt act may suffice. So ordinary contractual principles, it's no surprise or nothing unusual to say they don't produce a clear answer in every single case. But what they indicate is, at the very most, all an employer has to do to effect termination is, as per Lord Justice Lloyd's judgment, is achieve delivery of the notice to the employee in a way that was made clear in advance and that in the ordinary course of events it's their normal address. And if one does that, then ordinary contractual principles do not require anything else to happen for termination to be effective. It may be that ordinary contractual principles don't, on the facts of the case, require even that much. I'm thinking in particular of the last stage. So even without delivery, it may be that the ordinary contract answer will be that even without delivery, a party has brought a contract to an end, termination has taken effect. But one of those two is right, and certainly ordinary contractual principles don't require anything more than that. My lord, I said that I would answer to
No, I follow when you put it in the negative. Again, I'm not saying I agree with it, that you can say in pretty general terms that ordinary contractual principles don't require proof that the notification actually got into the mind of the recipient.
Exactly, my lord.
But it's slightly less clear as a matter of ordinary contractual principles, isn't it, as to what is required?
Yes, my lord.
Which is why, I'm not trying to be rude in any way, you're sitting on the fence as to whether it's when it's posted or proof that it's delivered.
Well, I think, my lord, I did try and climb off I was conscious of that potential objection, and I thought I had climbed off the fence to say that if you were asking me which side of the fence I'd get off on, I would say delivery, as found by Lord Justice Lloyd. And the reasons I gave for that is because that is subject to the issue of personal service. It's impossible to expect an employer to do any more than that, whereas you could always say with posting, well, the employer could send it recorded delivery or special delivery. So that's the limit of the contractual principles. Practically, there is no reason either for requiring any more than that either. The only thing I've been conscious, just the only sort of caveat to that is that I don't hold a brief for that argument alone, because whichever argument's right, we win. So it may be that there's an argument out there to say that the law shouldn't go quite so far, and in fact posting is enough. But, my lord, I'm off the fence on the side of delivery.
Well, is there any more that you need to cover? I think we've gone fairly carefully through the points in your written case.
My lord, there was only one other thing I was going to do fairly briefly. And I can even hand this in if this helps, although I don't think it will, is just to go through the reasons given by Lord Justice Mummery for not following the contractual approach and what's said by Lord Justice Lloyd about that.
Yes.
Because they match up. And I've just got very, very brief comments on some of them.
These are the 5 reasons.
Exactly.
Yes.
My lord. I've got very, very brief comments only on some of them, because as I said in the written case, I adopt what is said by Lord Justice Lloyd on all of these. And I didn't think I could improve upon them or that anything would be gained by repeating them expressed differently. But if I run through this, and particularly with the paragraph numbers, the first is paragraph 34, and for the court's note, the response comes from Lord Justice Lloyd at paragraph 71. And what I've done, and I only offer this if it's any assistance, is put the two side by side.
Yes, that's very helpful.
In a table. I don't have copies, I'm afraid, my lord, because I wasn't sure, but it will be... All it is setting them out in any event side by side so one can see them. Paragraph 34, the first reason is that the context is statutory, and the 3 months has been given by Parliament to present a complaint to the Employment Tribunal. And the response to that, paragraph 71, is to say that whilst it may be different, a statutory rule is different from the common law rule, Lord Justice Lloyd said, it seems to me that in general the test should be that applicable under the general law, and a different approach should only be adopted for good reason, so as to avoid the date depending on subtle legalities. See the court case. Although what one could add to that, this is my 2 brief comments on this, is not so much the subtle legalities, but as the subtle factual nuances between what's reasonable in each case. The second observation, or very small point that I would add No, I'm sorry, this comes under the third, my observation of that. That's the only additional comment I had on that. The second reason is paragraph 35 and is responded to at paragraph 72. The critical act triggering the time limit is that of the employer. So in a nutshell, Lord Justice Murray is saying, well, it's your decision to do this, and therefore you must be taken, or you have to bear the consequences of your chosen method of communication. Lord, in my submission, that's not really a particularly compelling argument, even just on its face. But practically, Lord Justice Lloyd puts his finger on the potential downside of that, which is to say that it would be undesirable to discourage employers from taking time after such a hearing to reflect on the outcome and to formulate their reasons for dismissal. Now, that is, in my submission, unarguably a good thing. And I'd have thought that even most employee organisations or employees or trade unions would not wish employers to feel pressured into making a decision sooner than they might otherwise. And if that's right, then the only real option that the employer has, to be absolutely certain, is to call the employee back in and tell the employee, which might not be desirable for all sorts of reasons. One can imagine a very difficult gross misconduct case where effectively it's found the employee has harassed someone or stolen company property, and the idea of having them back in the company just to tell them. Then that leaves matters like the telephone and other modern means of communication. But one can have exactly the same potential difficulties with an email. Did it get through? Did it bounce back from the server? Were there problems with that?
It's not really a question of timing. It's a question of mood that Lord Justice Mummery is referring to.
Yes.
In paragraph 35. And the answer given by Lord Justice Lloyd does focus on timing rather than method.
Well, my Lord, with the greatest respect, I'm not sure I agree with that. Paragraph 35, as I said, it is quite discursive, paragraph 35. It's general consideration rather than formulation. But what Lord Justice Murray seems to be saying is, you've chosen to do it by the mode, as you say, my Lord. You've chosen the mode. And therefore, any adverse consequences of that, I'm afraid, are for you. You can always avoid the potential adverse consequence by doing it face-to-face. Yes. And what Lord Justice Lloyd's response to that, and this is the only part I disagree with, my Lord, about timing, is where he says it would be undesirable to discourage employers from taking the time by using that mode. Because, as I've said, if one's going to take time, what other mode of communication is appropriate after a period of time?
Well, you bring them in after a period of time.
Well, my Lord,
bad news face to face.
My Lord, they were the submissions that I made as to why that might not be at all appropriate.
Well, speaking again for myself, I wasn't at all convinced by the reasons that you gave. In fact, if you want to give bad news, the brave and correct thing to do is to do it face to face.
Well, my lady, I think, I hope it's not disrespectful to say that reasonable people could disagree about that, or at least to the point of saying that this consideration should count.
Well, we're talking about what's reasonable, aren't we?
Well, I'm not sure we are here, my lady, because this is Lord Justice Mummery's reasons for why the ordinary contractual approach should not be the one that's followed.
Well, you keep on putting it that way. It's in effect his reasons for saying that Brown, the established rule in Brown, is appropriate in this context. That's
my lady, I'm sorry, I won't quibble with that. I wasn't seeking to disagree with that way of putting it at all. I'm starting perhaps from the other end and saying, is an employer who wishes to communicate by letter, is that a consideration that really is relevant in deciding or carry as much weight to be one of 5 factors as to why the rule should be as it is? And in my submission, for the reasons given by Lord Justice Lloyd, it's not. I would say that at best the considerations are neutral either way, because I quite agree, my lady, that in terms of what is the bravest way to do something, but that doesn't mean that an employer that chooses not to do that is not being brave. The employer might have very good reasons.
We're back to who takes the risk, aren't we?
Exactly, my lady, that's exactly what it's all about.
Yes.
Exactly. It's exactly what the whole appeal is about. And what I say is, in a nutshell, is that where one strikes the balance, and I've said this in my written case, and this is where I came off the fence, is to say that the closest to the middle of the balance of risk is with Lord Justice Lloyd. And that's in the middle of the two parties.
Yes.
The third factor I would summarise as paragraph 36, which is responded to at paragraph 73 and 74, is what Lord Justice Mummery calls in the first sentence the need for fairness in the dismissal process. But what he goes on to talk about, he means in particular, is that one should have a full 3 months. And again, I don't seek to repeat what Lord Justice Lloyd says in response to that at paragraph 73 and 74. But the only point I would add to what's said there is that what Parliament has in fact provided is for there to be 3 months from when the termination takes effect, not 3 months from when the employee knows of the dismissal. If that had been what Parliament had intended, for the 3 months to run from the date of knowledge, then no doubt it would have said so. I don't say that because Parliament didn't say that, it can't have meant it. But there's an element of circularity in paragraph 36, because the 3 months runs from whenever the correct effective date of termination is. That's all Parliament's provided for, no more and no less. The fourth matter at paragraph 37 and responded to at paragraph 75 is precedent and the role of related considerations of certainty in practice and consistency in approach. And really I've made my submissions on that. And this is where I began at the start of the day, that it's not quite right to say that there is a clear and consistent line of authority across the board. I've not taken the court to all of these cases, but they're largely self-explanatory. We did touch on Potter.
Yes.
And there's sort of really cases where the facts can be quite easily summarised and the principles summarised. And then the fifth factor at paragraph 38 and responded to at paragraph 76 is the absence of legislative intervention. And again, I think I would just put my response to that in the same category as my exchange with my Lady Hale about the second factor, about the mode, is that factor can't bear the weight given to it by Lord Justice Mummery in terms of being relevant to determination of the correct answer. The matter's not been considered even by the Court of Appeal directly until this case. Still less has there been any consideration by this court or the House of Lords of the matter. And I just mentioned earlier, it's not in the bundle, but the well-known case of Malcolm and Lewisham, where not only had it wasn't quite so long-standing, but Parliament had, since the decision in Clark and Novacold, actually legislated on the basis that Clark and Novacold was correct. That was not found by the House of Lords to be a good enough reason to divert it from coming to what it felt, the majority felt, was the correct construction of the statute. I appreciate that my Lady Hale will have a different view about that argument.
I think I was proved right, actually, Mr. Greatorex.
Parliament has...
fairly swiftly.
Yes, exactly. Well, that really very neatly brings me to the final point that I kept saying I was returned to, although I have addressed already, which is that the question of section 128. Because I wouldn't be being realistic if I suggested that on Lord Justice Lloyd's approach there was not the potential for some prejudice to employees. But I would invite the court to take my acceptance on the narrow basis it's offered, which is that it is unlikely in my submission that that potential prejudice would, in practical terms, be real, or at least for more than a very small handful of people. And when we're in the context of a rule that otherwise applies to 236,000 claims, I don't have the figures for unfair dismissal, but it's safe to say that the claims for unfair dismissal will be in 6 figures at the very least. And we have a very, very small number of claims under section 128. The first point is, and this is why I said it led on neatly from the last point, is that Parliament may well, if it feels there's a problem here, it's very easy to, by a very, very slight amendment, to introduce the reasonably practicable extension to section 128.
Of course, another way of approaching it is that they were sanguine about section 128 because of the interpretation given in Brown.
I'm sorry, my Lord, could you...
That Parliament was sanguine about introducing section 128 because of the interpretation given to section 97 in Brown.
Can I just have a moment? My Lord, that of course is a possibility that one can't discount, but this is inevitably in complete speculation. And the fact that Parliament chose to have the reasonably practicable section for claims for unfair dismissal, but not here, is perhaps a consideration pointing the other way, because it accepted that there is a difference between the two. Why would it introduce a reasonably practicable extension if it had at the front of its mind the approach in Brown, which means that it doesn't take effect until you've read it or had a reasonable opportunity in any event? There's less need for that exception if the rule is in Brown, whereas if the rule is, as Lord Justice Lloyd said, then I can see it's important that it's there. But my main submission on section 128 is leaving aside the numerically tiny number of cases, a proportion of those overall, and leaving aside what I submitted, the overwhelming arguments in favour of Lord Justice Lloyd's approach. One has in my submission to think very carefully about how realistic it is it will cause problems in any case, even for one or two individuals. And I dealt with this in my written case by saying that Lord Justice Lloyd answered his own query about what if people are away and so on and so forth by saying, has the employer done everything that can reasonably be expected? And there may well be scope in cases where the employer knows that the employee is away, or knows that the employee is not at his or her usual address, or would not otherwise know about it, and there is a means which the employer could use instead of perhaps writing a letter or a different address or whatever, and chooses not to do it, then it may well be very difficult for the employer to show that has been done. So that is a safety net in itself. And the reality is, as this case shows, is that when people are called, for example, to gross misconduct hearings, which is the sorts of cases where this is likely to arise, then they're fully alive by the fact of the hearing as to what's going on. They have the opportunity to ask when the decision is going to be given. If they're worried they're about to be dismissed for whistleblowing or for any of the other protected reasons, they will know, or they have to be taken to know the seven-day time limit, and they can make inquiries when will the decision be published. And if they're going to go on holiday, they could say, well, this is a problem. They have the opportunity to deal with it. It comes back to my submission that employees are not the same as children. They might not be sophisticated in terms of legal terms of art and the law, but employees can be relied upon where their jobs are at risk and where they think they might want to bring a claim to put themselves in a position to know when they're going to find out the outcome.
Well, I think you're reaching the point of repeating yourself for
I'm
very
sorry,
understandable reasons.
Well, no, that was really on the point of section 128, because I wanted to try and persuade the court that any concern about that should not divert this court from the conclusion it would otherwise reach. My Lord, I don't think... If I may have just one moment.
Yes, of course.
Yeah, my Lord, that was the end of my submissions, unless there's any matter upon which I can assist.
No, I don't think so. Well, Mr. Greatrix, we're extremely grateful to you for your very careful presentation, both in writing and orally today. We will take time to consider our decision.
Thank you, my Lord.